Hello, ladies and gentlemen. My name is Bartosz Brozek, and I would like to speak about the architecture of the legal mind. In other words, I would like to pose the question, what are the mental mechanisms, the mental instruments lawyers have at their disposal while dealing with legal problems? Let us begin with a quotation from a famous American jurist, American lawyer, Thomas Reed Powell. Powell famously said, if you can think about something that is related to something else without thinking about the thing to which it is related, then you have a legal mind. What Powell wants to say here is that lawyers, probably unlike other professions, are well trained and well prepared to deal with highly abstract things, highly abstract arguments. In other words, the legal world, according to Powell, is the world of abstraction. This seems to find confirmation in various methodological treatises, methodological textbooks, which law students need to go through when they study law. For instance, in the German jurisprudence, one of the most famous kinds of books is or are the books on the so-called Methodenlehre der Rechtswissenschaft. And when we look at the table of contents of a typical book on Methodenlehre, like the one by Karl Lorenz, we find a number of topics that lawyers should be acquainted with, and all of those topics are highly abstract. For instance, in Lorenz's book, the things that the student learns while perusing the book are the structure of legal provisions, legal syllogism, rules of linguistic interpretation, rules of systemic interpretation, rules of functional interpretation, legal definition, legal loopholes, collision rules, or the structure of legal system. It seems, therefore, that what lawyers do is to use highly abstract rules of reasoning to deal with highly abstract problems. When we read methodological textbooks on law, another theme that transpires is that when we think as lawyers and like lawyers, we think in language. We use a very elaborate conceptual scheme. We use very complex argumentation structures. We also construct very abstract and highly coherent theories. And this insistence of language as the main tool that lawyers use in thinking is fully consistent with this idea that the legal world is the world of abstraction. However, when we look at more recent textbooks on legal methodology, in addition to all the tools for thinking in language, we also find some mentions, at least, and sometimes even a more elaborate treatment of another way of dealing with legal problems, which is intuition. By intuition, I understand here all mechanisms of unconscious decision making. So this may be called intuition sensu largo. Everything that happens in our unconscious mind and influences the way we are dealing with legal problems is under this umbrella term of intuition here. Now, when we look at those two ways in which, according to methodologists, lawyers think and solve legal problems, there seems to be a problem here. The problem is that it seems that thinking in language, so an activity which is conscious, which is time-consuming, which requires a lot of effort, is something completely different than those mechanisms which lead to unconscious decision making. Because unconscious decision making is something which is largely effortless, something which does not necessarily require time. An answer to a question, a legal question that pops up from our intuition, comes as if from nowhere. So it seems that lawyers use two different ways of dealing with legal problems, and those two ways are completely different. They have nothing in common. So it would seem that the legal mind is highly dualistic. There are, in fact, two different legal minds. The one which is rational and which uses language and linguistic tools as means for solving legal problems, and the unconscious and uncontrollable intuition. I have always found this very puzzling, that we indeed conceptualize the legal mind as consisting of two different and disconnected modules, let's say, or parts. So I think that it is at least reasonable to ask the question whether it really is the case that the legal mind consists of two separate and mutually isolated mechanisms. The one which enables us thinking in language, and the other which can be called unconscious intuition. I think that this question is important, in particular because our experience with we are dealing with legal problems is not of doing two parallelly two completely different things. We are dealing with legal problems, sometimes listening to our intuition, sometimes trying to construct elaborate linguistic arguments, but in all cases it seems that those two ways of approaching legal problems and solving legal problems are so interconnected, intermingled, that to say that these are two separate ways, separate mechanisms, seems somewhat dubious. So my claim is that there is another element in the architecture of the legal mind, an element which lies in between and links together thinking in language and unconscious intuition. And my claim is that this missing element, this missing link, is what can traditionally be called imagination, and in the context of the contemporary cognitive sciences, it may be called or identified with the mechanism of mental simulations. So let us have a more detailed look at all those three elements with particular attention or particular focus on imagination as the missing link between thinking, language, and intuition. But before I will try to show how mental simulations or imagination links together language and intuition, I will spare a few more words on those two more traditional mechanisms identified with solving legal problems, which is intuition and thinking in language. When we think about intuition, as I said, we should think of all the mechanisms which lead to unconscious decision making. So in the contemporary cognitive sciences, there is no one commonly accepted theory of what intuition is and what those unconscious mechanisms are. But we can identify at least two different ways of unconscious decision making, which surely fall under this umbrella term of intuition sensu largo. First, we can speak of intuition sensu stricte. Intuition sensu stricte is a kind of unconscious mechanism which works fast, it is automatic, it is not controllable, and it is experience based. So when we appear as young human beings in this world, we interact with others, we encounter problems, and we learn how to deal with those problems. How to close the door, how to respond to an adult, what kind of behavior is acceptable in a restaurant, what will bring a smile in the face of our mother, and so on and so on. Through this experience, we learn to associate certain reactions, reasonable or acceptable reactions, with certain circumstances. At some point, we will just react in an unconscious way. We do not need to think or consider the possible courses of action and choose between them. We will just act in the way in which our unconscious mind has learned to react to the given set or type of circumstances. And this happens all the time. Our intuition sensu stricte is a heavy-duty mechanism. Whatever problem we encounter, our unconscious intuition comes up with a solution. It does not necessarily mean that this is a good solution, but this mechanism is constantly at work. There is, however, another mechanism which works at the unconscious level, and which in psychological literature is usually called insight. Insight is also unconscious. It is also something which appears in our conscious mind. So the outcome of the work of the insight appears in our conscious mind in an unexpected way. But in contrast to intuition, insight is not something which happens all the time. It happens very rarely in situations which are impulse related. If for some reason we cannot easily find a solution to a problem, there is an impulse, there is a certain time between we stumble upon a problem that cannot be solved and the possible solution. Probably during this time our unconscious mind does a kind of restructurization of the problem, something happens there, and then a solution which seems qualitatively new and unexpected appears in our conscious mind. So one may say that when intuition is a heavy-duty mechanism, intuition sensu stricte of course, insight may be called a special task force. This is a mechanism which helps us to solve unexpected problems, but we solve them without conscious effort. We solve them because of the workings of our unconscious mind. So these are two from among probably many more mechanisms which are at work when we are speaking of solving legal problems in an intuitive way. Let us now think about thinking in language. Thinking in language is usually at least a conscious effort, and the emergence of language and the fact that we can use language to solve our problems has significantly changed the way human beings are able to deal with the issues they encounter in their environment. The reason for that is that language comes with a number of, and thinking in language comes with a number of very intriguing features. First, language brings objectivization. When we speak the same language, we have similar word models, similar worldviews. Therefore, we identify the same problems. When we identify the same problems, we can work together to solve them, and so on and so on. So, thanks to language, our world becomes more objective, and at the same time, the problems that appear in this world may be solved collectively. Another feature of language is that it enables abstraction. We can think in abstract way only because we use language. Without language, abstraction is impossible. And abstraction, as it turned out in the history of humankind, is a good mechanism, something which helps us to identify similarities between phenomena which are, prima facie at least, completely dissimilar. Another feature of language is that it enables theorization. We can use language to construct theories. And when we construct theories, we structure and unify our experience. So our world, the world we share with others through using the same language, our world becomes less fragmented, becomes more coherent and unified. And finally, language also brings what may be called dialogization. It is only thanks to language that we can discuss problems with one another, put arguments in favor or against some particular solution. So it is language which gives us the ability to not only see the same or the problems in the same light or identify the same problems, but also to work on solving them together through dialogue and discussion. So, as I said, from the traditional perspective, lawyers, when dealing with legal problems, have at their disposal two different mechanisms. There is intuition, and there is language. And my claim, as I said, is that there is a missing link between the two, and the missing link is imagination. And the question is how imagination connects thinking in language and intuition. So when we think about the link between imagination and intuition, we can speak of the heuristic function which is performed by our imagination, our mental simulations. Imagination helps to solve problems with the use of intuition. When we think about the link between language and imagination, what we can say is that vis-a-vis language or thinking in language, imagination plays a hermeneutic function, which means that imagination or mental simulations help us to understand linguistic expressions. And in this way, imagination is something which links also intuition with thinking in language. When we have linguistic constructions, we can understand them thanks to imagination, but then we can use those abstract, sometimes very abstract theories formulated in language to form mental simulations which then perform heuristic functions and help our intuition to arrive at a solution to the given problem. So let us have a closer look now at how imagination works. As I said, imagination in the perspective or in the context of the contemporary cognitive sciences may be identified as the mechanism of mental simulations. What are mental simulations? Well, people, but probably also other animals, have the ability to imagine things in their minds, to play out a particular situation, or to see with one mind's eye an object. There is a very good evolutionary explanation of this ability, which is well summarized by one sentence. It is better to die in one's imagination than in reality. So it seems that evolution has selected the mechanism of mental simulations because mental simulations help us to prepare to the problems that we may encounter in our environment with relatively little cost. In the recent decades, a number of very intriguing studies have been done on what are the neuronal mechanisms behind mental simulations. It turned out that when we imagine something in our minds, we use more or less the same areas of our brain to those we use when really observing something or doing something. So when I imagine a chair, I use more or less the same regions of my brain as when I see an actual chair. When I imagine my favorite football team winning Champions League, I use more or less the same neural structures which would be active if I really observed my favorite football club winning the Champions League. Another interesting thing is how mental simulations help us to process linguistic concepts. It turns out that, again, when I use a word, read a word, or hear a word, like chair, more or less the same regions of my brain I activated to those which are active when I see a chair or I merely imagine a chair. So in other words, it seems that mental simulations are what is instrumental in understanding language, at least the concrete language, not very abstract concepts, but concrete concepts such as chair, football field, or something like that. Another interesting thing about mental simulations is that they are multimodal. So to imagine something does not mean only to see something with one's mind's eye, but also to hear something in one's mind, to experience an emotion. So let us come back to the example of my favorite team winning the Champions League. When I imagine it, I not only see this happening in the stadium, but I can hear chants from the crowd. I can feel the emotion when the captain of the team lifts the trophy, and so on and so on. This is the multimodal character of mental simulations. Another interesting thing is that mental simulations are not necessarily conscious. Of course, when I actively try to imagine my favorite team winning the Champions League, this is a kind of conscious mental simulation. But as the research shows, the simulations may also be unconscious, as when we process language. When I read the sentence saying that my favorite team has just won the Champions League, beating Real Madrid 5-0, I don't really consciously entertain the picture of my favorite team winning against Real Madrid, but this happens, or something happens at the unconscious level, and these are in fact mental simulations. Finally, there are quite important individual differences between people when it comes to mentally simulating someone. Some people, at least at the conscious level, can really see their team winning the Champions League way they try to imagine it. Other people are not able to mentally see it, However, when they try to imagine such a situation, there are at least some indicators that indeed a kind of mental simulation is going on. For instance, some emotions are present, or the person may see or seem to see with their mind's eye some aspect of the situation at least. But we need to remember that when we think of mental simulations at the conscious level, there are important individual differences between people. So these are mental simulations. As I said, mental simulations may perform the so-called heuristic function. They serve or may serve to evoke intuitions, educate them, or search for insight. So this is the function which imagination or mental simulations perform vis-a-vis intuition, which is all the unconscious, that is all the unconscious mechanisms of decision making. It is easy to explain why this is the case. If I imagine a situation, and please remember that mental simulations are multimodal, I activate more or less the same brain regions which are activated when I would just live through the given situation. If this situation is a problematic one, for instance, we imagine a legal case or a moral dilemma which does not really exist in reality but may exist. So when I imagine it, I activate the emotional reactions. The emotional reactions are strictly connected with our well-trained intuitions. So when I'm thinking or imagining a situation which is connected to a moral dilemma, it is quite likely that imagining it would evoke an intuition, and this intuition will tell me to solve the dilemma in one way or another. We also use imagination or mental simulations to educate intuitions. And this is exactly what happens when we try to teach law students how to understand a crime, how to ascribe guilt. We do not do it as law professors only by providing our students with abstract definitions. What we try to do is that we provide the students with particular cases, saying, look at this case. In this case, no guilt can be ascribed to the perpetrator. Look at another one. Here, the guilt is ascribable. Mental simulations may also help to search for an insight. When we have the situation of impasse, when our intuitions are conflicting or are not strong enough to provide an answer to a problem, we can try to imagine not only the given situation that we are dealing with, but also maybe slightly different situations in the hope of stumbling upon a new solution, in the hope of gaining an insight. But is imagination really used in legal thinking, legal reasoning? Yes, it is. Here is a very nice example. It's a case of Kearney versus California from 1985. In this case, Mr. Kearney was accused of trafficking in marijuana from inside of a camper van which was parked in a parking lot. And then the police searched the camper without a warrant. They found the marijuana there. And the legal question, the legal problem was whether this search was legal or illegal. And the problem is that if the right to privacy, especially in one's house, is taken into account, then the police search would turn out illegal, so all the evidence found would be deemed inadmissible. However, if there is a risk of the loss of evidence, and we are dealing with a vehicle and not someone's house, then the police has the right to search a vehicle, and whatever is found there is admissible in court. So, in Kearney versus California, Kearney lawyers claimed that Kearney's right to privacy was violated, and the evidence is inadmissible, while the California lawyer tried to show that Kearney's camper van cannot be understood as his home. Rather, it is a vehicle, and in this case, the risk of the loss of evidence makes the search legal and the evidence admissible. And here is a very intriguing discussion between the judge and one of the judges in the case in front of the Supreme Court and California lawyer, which goes like that. The judge asks, "What would you do with a houseboat?" A houseboat, says the attorney, "I think that would be covered by the legal norm allowing the police to search it without a warrant. It has wheels. No, it's a vessel and it is covered by the same rule." "Well, I want to be more specific," says the judge. "There is a houseboat. It's tied up to a dock that's got no motor on it at all. It's just sitting there. And it's hooked up to the sewage, electricity, etc. And it's right beside the house. The house is covered and the boat is not." And the attorney says, "That's correct. It's sort of like an automobile that is parked right next to the house and the driveway. The automobile might not be covered and the house is. But the automobile has a motor in it. That's correct. And the houseboat does not. No, there may be oars. There may be some way to move that from one place to another. There may be. I've seen houses moved too. As I've passed a few of them on the Beltway. You've got to get more than that. Certainly, again, the objective indicia of mobility would be," and so on and so on. I will not continue with this conversation. The intriguing thing here is what kind of argumentation it is. It is not an abstract argumentation. What the judge is trying to do is to imagine different sets of circumstances which are somewhat similar and somewhat dissimilar to the situation at hand, to the camper van of Mr. Kearney, in order to, in fact, activate various intuitions. We think about the houseboat. If this houseboat is placed near a house for good, it's not used in any other way. What happens if it is connected to electricity and the sewage system? Does this change anything? Why do we ask those questions? We all ask those questions because small changes in the given situation may lead to a different emotional reaction and, in fact, to different intuitive answer that we give to the given case. So when we have a difficult case like with Kearney versus California, what we try to do is to use the principle of variability. So we start imagining not only this particular situation, which apparently gives rise to no clear intuition, but we try to change the circumstances in the given situation in one way or another and see what happens at the intuitive level. Whether an intuition will be formed that will give a clear answer to the given question. The same thing happens in legal philosophers' favorite example of vehicles in the park, when we have the local ordinance banning vehicles from entering the park. So we have a rule: vehicles are not allowed into a public park, and pose a question of whether a bicycle rider can enter the park lawfully, or this is a violation of our legal rule, then what we can do, and what legal philosophers have done for many decades now, is to imagine various versions of this situation. So we can have a car entering the park, and in this case it's clearly a violation of the rule. We can have a bicycle, a scooter, an ambulance carrying a seriously injured person, an electric wheelchair, a moped, roller skates, tank which is brought into the park as a war memorial, a Spitfire from the Second World War, and so on and so on and so on. So this is how imagination, mental simulations are used in their heuristic function to solve problems. But as I said, mental simulations have also another function, the hermeneutic function. They help us to understand language. When it comes to processing of concrete concepts such as bicycle, car, park, drive-through, this function is pretty straightforward. The recent studies show that when we hear or read such concrete words, at the unconscious level we mentally simulate them. So we understand what the sentence bicycle drove through the park means because we simulate this situation at the unconscious level. The problems emerge when we ask the question of how abstract concepts such as vehicle, fiscal obligation, meeting of the minds, how those concepts are processed. Is there any role for mental simulations there? So this is one of the biggest puzzles in the contemporary cognitive science, which is the puzzle of abstraction. And there are many different theories which try to answer this puzzle, like George Lakoff's theory of conceptual metaphors, like the dual coding theory, and so on and so on. None of those theories is commonly accepted. What they have in common is they try to show how the mechanism for understanding abstract concepts is in one way or another rooted in our ability to understand more concrete concepts. For instance, in the theory of conceptual metaphors, as Lakoff says, we understand abstract concepts because to deal with abstraction, we use the inferential structure of a set of concepts which are more concrete, and this is the process of metaphorization. But even if we do not know exactly how abstract concepts are processed by our brains and how we understand them in our minds, I believe that we still can say a few things of how mental simulations are used, even in the case of understanding abstract language, abstract concepts. I believe that what we do is that we use three different tools. The first tool is exemplification. We simply provide examples in the context of the law of acting in accordance with or in violation of a rule, or examples of some things which fall under a central concept or not. For instance, when I consider the legal concept of a vehicle, I may say that bicycles are vehicles, cars are vehicles, roller skates are no vehicles, and so on and so on. I exemplify. And of course, in this context, the key role is played by mental simulation. The second tool we can use is paraphrase. What we do while paraphrasing is that we formulate alternative equivalent formulations of a legal provision. So, for instance, instead of saying vehicles are not allowed into a public park, we can say that this is equivalent to vehicles equipped with a combustion or electric engine are not allowed to enter the park. When we accept such a paraphrase, this facilitates our exemplification. Because if this is an acceptable paraphrase, then bicycles, which are not equipped with a combustion or electric engine, do not count as vehicles. Therefore, someone riding a bicycle may enter and ride through the park. Finally, the third mechanism that we have is that of embedding, which means inscribing the provisions or paraphrases, accepted paraphrases, into a broader theoretical context. Why do we do that? Because we understand that the law should be seen as a coherent system, as a coherent whole. Therefore, when we take a legal provision, or better yet, a paraphrase, an accepted paraphrase of a legal provision, like vehicles equipped with a combustion or an electric engine are not allowed to enter the park. And it turns out that this definition, or that this paraphrase, is not coherent or is inconsistent with something which appears in a different place in the legal system. For instance, a rule saying that vehicles which are equipped with electric engine should not be treated as in the same way as vehicles equipped with a combustion engine, because electric engine does not contribute to the deterioration of the environment, while the combustion engine does, and so on and so on and so on. Then the process of embedding serves to select or choose some and reject other paraphrases. So while embedding paraphrases of provisions into the context of the legal system, we may reject some of them. So ultimately, this also serves to facilitate exemplification. Embedding helps us to select paraphrases, and paraphrases help us to exemplify particular legal concepts or legal provisions, legal rules. So it seems, from what I've said so far, that legal interpretation is an interplay between mental simulations and linguistic constructions. When paraphrasing and embedding are only auxiliary tools, and the main tool is exemplification. The main tool is to say whether a given object or a situation falls under an umbrella of a more abstract term. From this perspective, we can understand a number of things which are important for lawyers. For instance, we can understand in a different light the role of interpretive traditions. The interpretive traditions are important because they help in the process of paraphrasing and in the process of embedding. But again, this is only an auxiliary thing, an auxiliary function that they perform. The same holds for various rules of legal reasoning, like rules of legal interpretation, collision rules, forms of legal argument. They help in the process of embedding. So again, they are only auxiliary tools when it comes to legal decision making, because the core of legal decision making is the process of exemplification. So the picture of this architecture of the legal mind that I have tried to sketch in this lecture is the following. Lawyers have three different tools at their disposal: thinking in language, imagination, and intuition. These three things are not disconnected. they are connected, but this is clearly visible only when we put imagination or mental simulation in the center of what the legal mind is and how the legal mind solves legal problems. This conception of the architecture of the legal mind that I have sketched leads to a number of interesting theoretical consequences and questions. For instance, in the context of the nature of legal language, what I have said only magnifies two problems that are already important for everyone working on the nature of legal language, which is the puzzle of abstractness and the role of abstract concepts and the way they are processed. When we think of the structure of legal reasoning, the perspective I offered in this lecture suggests that the role of imagination, of such things as exemplification or thought experiments or using analogy, has been largely neglected in the study of legal reasoning. This perspective I offer also underscores the non-foundational character of legal thinking. Legal thinking simply does not move from abstract and general rules through the description of facts to a legal decision, which is a decision in a particular case. This is much more the different levels, the level of the abstract and the level of the concrete, are much more intertwined and interconnected. From the perspective of the architecture of the legal mind that I sketched, one can also try to rethink the nature and role of logic in legal thinking. Still another thing that emerges or transpires from our discussion is the question about the rationality of legal thinking. If indeed imagination is so important in the way lawyers think, then the traditional approach to rationality, understood in the constructive way, and the reliance on this kind of rationality may be a mistake. Maybe we should think of introducing a different concept of rationality, the so-called ecological rationality, and try to ask the question of how the two, the constructive and the ecological, are interconnected. Let me finish this lecture by quoting a very interesting thinker, Giambattista Vico, who in the 17th century, writing about Roman jurisprudence, said, and recognizing the importance of imagination for legal thinking, said the following thing: ancient jurisprudence was throughout poetic. By its fictions, what had happened was taken as not having happened, and what had not happened as having happened. Those not yet born as already born, the living as dead, and the dead as still living. It introduced so many empty masks without subject. Jus iura imaginaria, rights invented by imagination. It rested its entire reputation on inventing such fables as might preserve the gravity of the laws and do justice to the facts. Thus all the fictions of ancient jurisprudence were truths under masks. All ancient Roman law was a serious poem, represented by the Romans in the Forum, and ancient jurisprudence was a severe poetry. I hope that I have persuaded you that law is not necessary or not only the world of abstraction, it is also, to an extent at least, a very poetic world. Thank you.